From pandemic disruptions to farm bankruptcy, 2020 was a big year for ag law developments. Now we continue our agricultural law year in review, and we're still working our way down the almost top 10 list with Roger McEowen with the Washburn University School of Law. He joins us now to review more in today's Rural Money segment. Thanks for joining us, Roger. As we move down the list, we arrive at a significant case in 2020 involving renewable energy cash grants. What are the big takeaways there?
Yeah, we sure did, Christina. Good to be with you. Well, this goes back to the 2009 economic stimulus package, and Section 1603 of that act created a green energy subsidy program. And basically what that created was a system of cash grants that energy companies could get in lieu of investment tax credits if they installed various types of alternative energy properties such as solar and wind and geothermal and biomass and hydropower. So it's all very important to ag. Now, because there are multi-millions of dollars at stake, of course, there's an incentive there to try to qualify for more than what you're actually entitled to. So IRS does audit these very, very closely, and they won a $10 million case in 2020 where the company had to pay back $10 million in cash grants that they had received because they had improperly structured their business activity. So it's a very significant case because the way the court said the IRS could compute the credit, it could impact the computation of those tax credits for future projects involving agriculture.
Let it be a warning to others out there. Excellent for you bringing that one up. Next up, we also saw developments in trust income tax regulations. What changed there that we need to know about?
Well, actually, this was the IRS being nice to us. In this instance, what we had feared was that the changes with the ATRA law that took effect 2018, which removed a lot of itemized deductions that individuals could take, we feared that those would also be removed at the trust and estate level. And the IRS produced some final regulations along with the Treasury in the latter half of 2020 that said, nope, those rules don't apply in the context of trusts and estates, so we can still get the basic deductions that we're normally used to in that context.
All right. Well, another big one was a federal case involving a Kansas law designed to protect livestock facilities. What do we need to keep in mind as a result of that case?
Well, this was a very important opinion coming from the Federal District Court in Kansas, where they construed what's commonly known publicly by the public as an Ag Gag Law. There are a number of states that have these. Kansas was the first state in 1990 to enact this legislation. And basically, these are designed to protect livestock facilities, and particularly confinement livestock facilities, from individuals that misrepresent their true intentions in trying to get a job there. And they're basically trying to shut the facility down or do economic harm to them. Well, a lot of the states that have enacted these laws have faced challenges, as did Kansas. In this most recent case, the court in Kansas, the federal court in Kansas, went along with the majority of the other courts and said that law was unconstitutional as a violation of free speech. So the legislature in Kansas, as well as in these other states, is going to have to reevaluate how they try to provide protections to these types of livestock facilities.
But at least it's definitely on their radar. We really appreciate you going down this list with us. Looking forward to more of it. Roger McEowen with the Washburn University School of Law, thank you so much for joining us.